So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being. I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
All right, folks, buckle up because today we've got yet another wild courtroom moment featuring none other than our favorite repeat offender, self-proclaimed sovereign citizen who's clearly not learning his lesson. It's just a week after his last hearing, he was granted bond. And what does he do with that freedom? He strolls into a local quick stop and decides to swipe some liquor, like it's no big deal. That's right, barely out of jail. And he's already back to making headlines for all the wrong reasons. Now he's standing in front of the exact same judge who released him just days ago. Let's just say the judge is not amused. Feel the frustration in the room as this sovereign citizen tries to spin his usual nonsense. But this time, the court isn't having it. The judge's reaction is nothing short of priceless, a perfect mix of disbelief, authority, and I told you so energy. So now the big question is, should this guy even be considered for bond again? I mean, if he couldn't stay out of trouble for a single week, what's stopping him from doing it all over again? Let us know in the comments, should he be locked up this time for good, or does he somehow still deserve another chance? And if courtroom chaos like this is your thing, don't forget to hit that like button and subscribe for more wild legal showdowns. Let's jump right into the footage. This one's a roller coaster.
All right, people of the state of Michigan versus Drew James Peltola, files 247831 SM. And file 247819 SM. Mr. Peltola appears from the Dickinson County Jail. Counsel
The appellation known as Drew James Peltola appears before you as an entity.
Hold on a minute. Just let me make the appearances, then I'm going to give you the floor, okay? In regard to the matter, Nancy Schaub is here as both his counsel on the underlying file on 247819 SM, as well as the first bond violation. She's here as CAFA counsel on bond violation number 2 in this file, as well as a new file of 7831 SM. Kristen Cass is here on behalf of the prosecutor's office. Drew Peltola, I'm going to give you an opportunity now to say whatever you want to say. Go ahead.
Ma'am, I was trying to get a ride to court this morning. This bond violation.
Wait, sir. I don't want you to talk about the underlying charges. I wanted you to say whatever you wanted to say. I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being.
So here we go, again this time. Our sovereign citizen walks into court waving around his latest so-called legal weapon. The infamous "I copyrighted my name" argument. Yep. He really believes this move is going to magically erase all the charges against him, according to his logic, by filing a copyright on his own name. He can somehow stop the court or the entire government from using it in legal proceedings. Sounds like something from a bizarre legal thriller, right? Now, if you're wondering where this idea comes from, here's the scoop. Sovereign citizens often cling to this tactic because they think the legal system operates like a business contract. They believe that if they own their name, it prevents courts viewed by them as private corporations from legally addressing them. They see it as a loophole to opt out of the justice system altogether. As if the law is just optional paperwork. The entire theory is deeply rooted in long debunked conspiracy narratives about how courts and governments supposedly function. Experts Judges and legal scholars have shut this down time and time again, yet somehow still shows up like clockwork in courtrooms across the country. Honestly, it's the legal equivalent of saying water's not wet just because you want it to be. Now, the real question is, does this guy actually believe this will work? Or is he just pretending to believe it to stall the case? It's hard to say. Either way, the courtroom wasn't impressed, and you'll want to stick around to see how the judge responds to this outlandish claim.
All right, is there anything else you'd like to state for the record concerning this issue then, Mr. Peltola?
No, there's not, Your Honor. I would just like to be released again on a PR bond. You have expedition charges. I'm asking the courts to please release me on a PR bond again, and I'll continue to abide by court rules and stay off of drugs and try to maintain my court dates.
All right. In regard to the matter, then, Mr. Peltola, I have an advice of rights and plea, and for the record, I will acknowledge your comments, that your objections in respect to the court's jurisdiction and whatnot are noted for the record. All right, concerning the matter, then, I have some concerns regarding Mr. Peltola. He seems to be on a spiral. This started with a disorderly drunk on February 4th in a public place. I saw him on February 5th. I set his bond terms. I saw him back on February 12th, with a .236 on a preliminary breath test. I set bond at that time on the bond violation and the underlying. And the reason I told him then that I was going to give him the break is that normally I see people in between, they get arraigned, I give them the warning, and then they come back on a bond violation. He had not had the warning in between because he violated his bond so quickly that I saw him all at once. So I told Mr. Peltola at that time that I would set the bond at a 1,000 PR, but understand that if he came back again, he would leave me no opportunity or new choice. So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop, involving another bond violation, as well as a new underlying charge that I'm free to assume is true for purposes of setting bond. So for purposes of setting bond today, then, for the following reasons, and in regard to his Wisconsin matters, very serious matters, he's got 2 felonies pending in Brown County from 2023. The first one alleges possession of narcotic drugs, a felony, possession of a controlled substance on or near certain places with a modifier, carrying a concealed knife, possession of drug paraphernalia. That case has been pending through for quite some time. And he has a court date for a status conference scheduled for February 26th at 11 a.m. Then, so the date of this offense was filing date of 2/10 of 2023. He's got a filing date of March 15th of 2023 in Brown County, another felony alleging bail jumping, as well as possession of drug paraphernalia. Likewise, that has a court date at the same date and the same time as the other pending felony.
I think that is part of the other pending felony. They charge it as a separate offense, but
It's a separate case, total separate case, total separate charges, total separate bond, total separate court dates. This is file 23 CF 448. The first one is 23 CF 240. So in respect to the matter, my point being, for purposes of setting bond, Mr. Peltola has some substance abuse issues going on. He's got numerous cases pending in Wisconsin as well as now here. In regard to the matter, Mr. Peltola, I'm going to direct you to talk to your lawyer. I'm setting bond concerning the new theft case. Then the conditions are going to be as follows. Mr. Peltola may not enter into the Norway Quick Stop as a condition of his release. He is not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Mr. Peltola is subject to random PBTs and drug screens. Mr. Peltola may not go in any businesses that sell alcohol for use inside, such as bars and taverns. Recreational and medicinal marijuana use and possession are prohibited until or unless further order of the court. Conditioned on him signing that waiver of extradition, which I do have in the file, I will allow him to go back and forth to Wisconsin for purposes of court hearings and or meeting with his.
Honestly, It's getting harder to understand why the judge keeps giving this sovereign citizen any leniency. I mean, at what point does enough become enough? This guy has made it crystal clear. He doesn't respect the law, the courtroom, or even basic common sense. From swiping bottles at a convenience store to throwing out bizarre legal theories like copywriting his own name, he's treating the legal process like a game he thinks he can outsmart. But here's where it gets serious. This isn't just someone bending a few rules. He's rejecting the entire structure of law and order, pretending as if rules don't apply to him. That mindset doesn't just create chaos. It endangers the community. When someone shows you again and again that they have zero interest in being held accountable, why keep giving them the benefit of the doubt? It's like we're watching a loopy gets arrested, says something outrageous in court, gets bond, and then goes right back out and causes more problems. And still the court keeps extending grace. Isn't that just asking for bigger trouble down the road? Some would say yes, absolutely. Others might argue he deserves another chance. But how many chances are too many? So what do you think? Is it time for the judge to draw the line and revoke bond altogether? Or is there some angle here we're just not seeing? Drop your thoughts. Because this case is quickly becoming a symbol of what happens when the system keeps giving passes to people who reject it outright. Let's jump back in and see what happens next.
If
In residency, he lives in Wisconsin.
in residency. No, he lives in Vulcan. Or he says Vulcan. Is that just your
Bracketed.
mailing address?
Yes, we can do it like that if you choose to.
Well, where is your residency?
My
Well, you-
residency and my domicile is 1968 River Street. We can switch it with a mailing address to W43, the apartment 13 in Vulcan, Michigan. The address should be in there. It should be bracketed.
Right, and that's apartment 13. You didn't put that on there though. Apartment 13?
Yes, ma'am.
And that's your mailing address though?
Yes, but the problem is that building's not registered anywhere. I had to go to the post office and I had something mailed and they told me that my mail was being returned and because there's no actual mailboxes in the building.
All right, so I got two issues I need to deal with here. One, do you live in Wisconsin? Do you have to go to Wisconsin for purposes of residency or just your court stuff?
My mailing address, my residency, and my domicile are all registered at my mother's house. There was some unexplained events that I will not say out loud.
I don't know where your
information.
mother's house is, Mr. Peltola.
Nine
Ma'am.
address.
River Street, Niagara, Wisconsin, 54151. My mailing address will be W45. That's the Norway or the Vulcan address. I can't remember that off the top of my head.
All right. So in regard to bond, then condition on, I'm signing a waiver of extradition. I'll allow him to go back and forth between Michigan and Wisconsin for residency, court appearances, meetings with his attorney. In regard to the matter, if you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. Concerning the amount of the bond on the new retail fraud, I'm going to set that. At 1,000 cash surety, 10%. In regard to the newest bond violation, then I'm finding for both of them, actually, I'm going to make a record based on the factors the court is required to consider under MCR 6.106, considering the frequency, the charges, the dates that I have mentioned, as well as the ongoing Wisconsin matter. I am finding that to release him on a personal recognizance bond would not adequately ensure public safety. In regard to the bond violation, concerning the matter, then I am going to set the bond violation at 2,500 cash surety, 10%. So, Mr. Peltola, those bonds are set. If you get out, you make sure to get in touch with your lawyer. If you're in
Can I say
custody,
something?
she'll be in touch with you. You may.
Can I say- Yes. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond Especially today, when I was arrested on a larceny under $200, somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
Oh, sure. Why not just drop all the charges and roll out the red carpet? Because, according to him, identifying as an American nationalist apparently puts him above the law. Sounds absurd, right? Yet here he is, standing in court with all the confidence in the world, as if his personal identity somehow overrides the authority of the justice system. The entitlement is unreal. This guy isn't just making bold claims, he's actively accusing the court of holding him unlawfully, all while racking up charges like it's some kind of hobby. He's out there committing crimes left and right, and then walking into court acting like he's the one being wronged. It's the kind of logic that would leave most judges speechless if they weren't already used to hearing this brand of nonsense from sovereign citizen playbooks. What's wild is that he keeps preaching about his rights, yet ignores every law that holds society together. He's all for freedom, just not for responsibility. It's like wanting to drive without a seatbelt, a license, or even a car that's registered but still demanding full access to the road. It simply doesn't work that way at this point. You've got to wonder, does he really believe the courtroom can be manipulated with these empty declarations? Or is this just another act to buy time? Whatever the case, it's not convincing anyone. So is this all just ignorance or a strategy gone terribly wrong? Let us know what you think. Stick around, because this situation just keeps unraveling.
All right, Mr. Peltel, I'm not going to argue with you. Your sovereign citizen has been noted for the record. In regard to the matter, you are under the order of the court. You're under the jurisdiction of the court. I decline to follow what your...
Can I at least tell you that I was arrested on a larceny charge that was dropped through a case prefix, UN, all incoming evidence? Can I at least have you admit that in the court of law that you guys illegally kidnapped me again with a larceny through John Rod D. Clark, Norway Police Department? Can I just have you admit that once?
No, Mr. Peltola, I don't even know what you're talking about. I will not admit that. Thank you to the jail. We are off the record on this matter.
These really feels like one of those moments where the judge should have gone with a much higher bond because, let's be honest, does anyone seriously think this guy won't be back out stirring up more chaos the second he walks free? I mean, how many times does someone need to show you who they are before the system finally believes them? It's hard not to feel like he's being handed yet another opportunity to repeat the same reckless behavior. And no, it's not harsh to want someone like this to spend a little more time behind bars. This isn't about petty mistakes. It's about someone who keeps rejecting the entire concept of accountability while doubling down on bizarre conspiracy claims. We're talking about a guy who shows zero intention of following rules and somehow still expects to be treated like he plays by them. Letting someone like this back out without serious consequences is like giving a lighter to someone who's already started a fire. Why roll the dice when the damage is already clear? The concern here isn't just what he's done. Notes: what kind of precedent we set when the system allows this behavior to go unchecked. It sends a message loud and clear. If you scream loud enough and act defiant enough, maybe the rules won't apply. And that's where things get tricky. Yes, fairness and civil rights matter. But so does protecting the community from people who consistently prove they won't respect the law. In extreme cases like this, the balance should shift towards safety and, many would argue, we're not shifting fast enough. What do you think? Is it time for a longer jail sentence? Or am I overreacting here? Drop your thoughts in the comments. I'd really like to hear how you all see it. And hey, if you enjoyed this courtroom breakdown, be sure to hit that like button and subscribe. Really helps out the channel. Thanks so much for watching, and I'll catch you in the next one. Stay safe out there.